the risk of being immediately objectionable, Deputy, I don't think you can bring sandwiches into the, or biscuits into the... Okay then. Right. Very well. We now, questions having been asked of the Attorney-General, the assumption that there are no more to come, we are then open the debate. Does anyone wish to speak on P106? Deputy Mezek.
Thanks, sir. Quite an assumption there. I was tempted to think of some more over the lunch break, but I think the Attorney-General has been very helpful in what he's, in the answers he's provided, which, if you ask me, are hook, line and sinker, which is that the Rent Control Tribunal we're being asked to establish will not have the power to do what it's being suggested it has the power to do. The tenancies which will fall under its jurisdiction to be able to adjudicate on are so good.
Hold on, we're going to get there.
Okay, is that okay? Yeah,
yes.
The tenancies that will be able to be adjudicated on their rental conditions when it comes to this tribunal will be so few and far between them so as to render this tribunal essentially powerless. Those tenancies where they will have jurisdiction are set out in Section 2 of the 1946 law, along with the exemptions, which are so wide-reaching and, in my reading anyway, appear to pretty much discount the tenancies which exist under the 2011 law, a law which is clearly out of kilter with the 1946 law, which uses very different types of language to describe what they apply to. So, for example, the 1946 law refers to houses, which the Attorney-General clarified that there may well be some case law that says that can include flats, and that is very different language to what's in the 2011 law, which provides much greater detail as to what constitutes a residential dwelling. These laws don't match. They don't work together. I would guess that that is probably one of the reasons that the tribunal fell into disuse previously. And accepting that it's probably inappropriate to use the floor of this chamber to organise any form of gambling, but I would otherwise have been tempted to place bets on how many cases will come to this rent tribunal if it's established, and I would have thought that the number that will arrive at this tribunal will be somewhere close to zero, which then poses the question, what is the point in using this law to appoint people to a body which will not have any real powers, won't be able to provide protection to tenants even in the short term, because there will be virtually no tenancies that will fall under its remit. It does render this exercise totally pointless. So that is why, despite me being very clearly on record in supporting the existence of a rent tribunal, that is why I didn't do it in the 2 years I was Housing Minister. There was no point in using this law to do so. And it's why I certainly will not be voting to appoint members to this tribunal today. It is a waste of time and money. It will not have any powers. It sends out a wholly unhelpful message to members of the public to suggest that there is now a body upon which they can rely on to help them, when in law they cannot rely on it because it doesn't have those powers. And it is much better to use this time and energy instead to put towards that comprehensive review of the residential tenancy law and the funding to do that, which originated in my time as Minister, because I knew that work was necessary in order to have a tribunal that one day will be empowered to effect proper rent control measures on residential tenancies. It is a much better use of our time and energy to get that law up to date, strengthen it along the lines which were proposed originally by the Housing Policy Development Board, to put in very clear restrictions on how and when rent increases can be applied, and importantly, to improve security of tenure. Because one of the other risks that occurs here is that if a tenant chooses to go to this rent tribunal, irrespective of whether the tribunal rules that they have jurisdiction over that case or not, they will be putting a big target on their back for their landlord to subject them to a revenge eviction. And in the Residential Tenancy Law of 2011, there are no real protections from revenge evictions. The only protection which exists is the Petty Debts Court being able to provide for a stay of eviction to, rather than evict them at the end of a notice period, but be able to step in and say this will cause hardship to the tenant, so they need a few more months at the very least. But the Residential Tenancy Law of 2011 states very, very clearly, in a periodic tenancy, the notice period is 3 months, and there is no need to provide a reason whatsoever. The landlord can do it because they fancy it, they can do it with reason, they can do it without reason. They have to provide nothing towards that, and only if there is hardship can a tenant refuse to budge, make them go to the Petty Debts Court for an eviction order and challenge it at that point, but there will not be a legal basis for saying no, absolutely not. You can't evict this tenant for the simple reason that the Residential Tenancy Law says they do have the right to kick them out. The only thing they'll be able to do is impose a greater time on the landlord to provide some leeway for the tenant if they're facing hardship. So we do not have adequate protection in law for people from no-fault evictions or revenge evictions, and this tribunal does not change that if constituted under the 1946 law. In fact, it provides false hope and it provides a risk to tenants that they may upset or anger those whose decisions they're trying to challenge, for which they will not have adequate protection from. They will not be empowered to stand up for themselves under this tribunal. And that is why, as a constituency representative, if this tribunal is established under the 1946 law, I will not, in good conscience, be able to encourage my constituents who come to me with concerns about their rental situations to engage with this tribunal, because I would be worried that I would be inadvertently giving them advice that would lead to them becoming homeless, and that would be an irresponsible thing for me or anyone else to do. So there is an alternative way around this, which is what the Minister should do, which is that he should withdraw this proposition, because for the reasons I've stated, it is a waste of time. It will have no power. It appoints people using a law which is totally superfluous to any of the other purposes that the Minister says he wants to use this tribunal for. It will not operate as a tribunal. It will hear no cases. It will not function in that way. If he wants to use a panel of people to help advise him to inform what is included in a reformed residential tenancy law, he has the ability to do that unilaterally without referring to this old law and without referring to the States Assembly to do that. It doesn't impose any of these requirements that exist in the law on that. He can get on with that, and that would be a better use of energy to do that. So that is in itself, I think, a very good reason for voting against this waste of time proposition. I'm afraid to say that there is a bit more to it, though, in why it should be voted against. And I'm going to be absolutely clear at the start of making this point, because there have been comments about members getting personal in these debates, and I will not make any comment whatsoever on the personal characteristics of the names we are asked to appoint here, for the simple reason most of them I don't know them. A couple of them I've met on a few occasions and like and respect. The ones who I haven't met, I have no reason to doubt their personal integrity or their willingness to contribute positively. So I make no comments on that whatsoever. What I'm saying is objective, which is that it is wrong and inappropriate for the chair of a membership organisation to sit on a panel where the tenants of those members will go to complain about those members. It's inappropriate and wrong. It doesn't matter who the person is, it doesn't matter how great they are or whatever the concerns are, that ticking that box alone makes that appointment totally inappropriate. It would be like having the chair of the police officers' trade union on the police complaints panel. That would be considered totally inappropriate because that person represents members and has a duty to those members to advance their interests, and that is incompatible with heading up a form of complaints process against those members, as so it is also for the chair of the Jersey Landlords Association to be a member of a body where tenants will be asked to go to complain about the potential behaviour and conduct of those members. That's inappropriate. Sir, I do not know the individual who is proposed for that. I have absolutely no reasons to doubt that person's ability or integrity, but it is purely by the fact that he holds one role that he must not hold this other role. That is totally inappropriate. And of course, sir, it's made even more inappropriate by the fact that earlier this week we received a communication from that body to lobby us, as of course they are free and able to do, which said in it, in their comments towards an earlier amendment debated in this state sitting about rent control, that that body opposes rent control. So how can somebody who is on record as part of an organisation which opposes rent control be appointed to a tribunal with the raison d'etre of applying rent control? It makes no sense whatsoever. It is an inappropriate appointment. So, sir, for those two principal reasons, the first being that this tribunal will have no power, will not be able to do what we're asking it to be set up to do because it is based on an out-of-date law which is not fit for purpose, and because there is a proposed membership which has, as part of it, something which will undermine any form of trust in that body's ability to operate objectively, that this position must be rejected, and we must say to the Housing Minister that the work he seeks to do in reforming the residential tenancy law is the place to focus his efforts on. That will, I hope, be a positive outlet for improving the rights of tenants, for providing them with protections against excessive rent increases along the lines of the protections that were proposed in the Housing Policy Development Board, which was for European-style rent stabilisation, a form of rent control which is evidenced in the jurisdictions that use it to provide for greater affordability in the rental sector to those tenants without many of the negative side effects that occur under other models of rent control. In voting against this, we'll be saying to the Minister, go ahead with that work. That is more constructive and that will hopefully lead to a better outcome. But don't use an out-of-date, not fit-for-purpose law to establish a body which will not be able to fulfil its entire purpose because of the terms in that law which make it out of date, which will provide false hope to tenants that it's a body that can help them in the short term, when in the short term it can't because of the law, and to appoint people onto it who, irrespective of any personal ability or integrity they have, because of another role they hold, clearly provide for what will give rise to a worry about conflicts of interest. Tenants will not be able to engage with this. It will not help them in the short term. And in voting against this, we provide for a better option for the Minister to seek to do what I certainly hope happens as soon as possible, which is the introduction of a fit-for-purpose rent tribunal and legislate for a form of rent control which is fit for purpose for Jersey, and not to waste our time with this mistake.
Thank you very much, Deputy. Deputy Scott.
Oh, I'm sorry. However, I will speak. I'm wondering if I might ask another question of the Attorney-General.
Yes, you can ask a question of the Attorney.
I was just looking at the way that this law is structured and the exclusion from its ambit of contracts which are expressed as conforming and conform to a standard form of written contract prescribed by regulations made under Article 7. So we kind of established that this law is already restricted because it applies to dwelling houses, but then it excludes from its ambit contracts, rental contracts that are of a term of less than 9 years on a written contract, which is expressed as conforming and conforms to a standard form of written contract prescribed by regulations made under Article 7. So perhaps I just didn't follow the answer to Deputy Beswick's question quite well, but that seems to suggest to me that if a contract actually says, I'm conforming, not that contracts, I'm talking first person, but I'm actually conforming with the regulations made under this law, then that gets excluded. And most contracts, presumably, because it's an old law, don't say that. I just wondered if that's my kind of interpretation, because it perhaps affects how many contracts might fall under its ambit. Thank you.
That's a valid point that the Deputy raises. I have to say I do not have in front of me contracts of residential tenancy contracts, but the point the Deputy raises is a valid one, that if the contract is expressed as conforming to a written contract, then arguably that might mean that it doesn't fall within the exclusion. That is a possibility. But this is an area where, as I say, it's not being specifically, there isn't a legal authority in the courts which governs this specific point. My view is that there are plenty of grounds for dispute and litigation over this particular law and how it applies. So I think it is, I remain with my previous point that I made in response to the questions to Deputy Mezek, that this law does need to be updated, and in particular its interaction with the 2011 law needs to be thought about carefully.
Does any other member wish to speak? Deputy Tanya?
Thanks, sir.
First.
So I think to reinforce the point, we're being asked to vote to appoint members to a board to enforce a law which either doesn't exist yet, or to enforce a law which we know, and Deputy Scott has quite rightly recognised it, so it's not a reform conspiracy here by any means, that it's a very flawed law, and the Attorney General has confirmed that. We only have a law that deals with rent control of unregistered buildings, and that's because lodging houses, because they're the only buildings in Jersey that have rent control. Now that opens up a very interesting question anyway. If rent control is okay for lodging houses, why isn't it okay for the vast majority of people who don't live in those rental properties, who rent in the open private market sector, or indeed even in social housing, which might also be subject to some form of rental control? And that's before we even, and I'm not even going to touch then on the composition of the board, because my position is the same as my party leaders, quite independently come to that, but also happy to abide by the party position anyway, which is that we don't believe that this is the right time to appoint any kind of board if you're setting them up to fail. This seems to me to be nothing more than window dressing, because there is nothing for this board to do. We're appointing them until 2023, but it's unlikely that there'll be anything for them to do until at least 2023. I can't see this government acting fast. That they're a government who are opposed to rent control anyway. They don't believe in rent control. They believe in as much market as possible, and in fact, even more market, please, and as little regulation as possible, it would seem. So, plus ça change, more of the same. And so I don't get what we're doing here, sir. And so it's with that in mind, sir, that I would ask for a reference back, not a move on to the next item, incidentally, because that would be entirely undemocratic. But there is something that we don't have as an assembly here, which we need before we can appoint people who may or may not be the right people for the job. And I'll save that argument for later. And, sir, I believe in making the argument for a reference back, you'll tell me if it's in order. I think we need to see the detail. Where have we heard about detail before with their army of civil servants who can work and do work very hard for them? I know they do, and they have to listen to these kind of debates. Even my speeches, sir. And the piece of information I would like is the law. I want to see the law under which the Rent Tribunal will be operating. I don't want to see a link to a document that a previous housing minister set up, which is already out of date. A housing minister who I got on very well with, but who has been ejected from this assembly, and the government of which was also ejected from this assembly by the electorate, sir. And I don't wish to see that redundant document which talks about ideas that are not from this assembly or even this government. I want to know what the government's plan is when it comes to a blueprint for that tribunal to work for, sir. So I know you are looking through the standing order, sir, and I would have quoted the number to you, but I'm sure you have it, and it's probably a good time to allow you to consider that, sir. And so if I may be permitted, it's simply the fact that we don't have a law. It's we also don't know the remit that the panel will have. We don't know the types of tenancies which this tribunal will be able to adjudicate on, whether they will be able to adjudicate on them at all, and if so, which kind. So when we have a constituent that comes to us and says, I've been living in a property, and I had one actually a few days ago in Groove Hill, and they said, I've been living in this property for years. The rents are now threatening to go up. There's works that need to be done.
Deputy, you've made a proposition for a reference back, and I think if you continue with your speech, then we can't have that reference back. My first question is, would that be seconded? Yes, sir. Yes. Very well. Could you specify what information or what further actions you're requiring so that we can consider the basis of the reference back?
Thank you. The two are intertwined. There may be other points, but certainly the two most salient points I can think of, sir, are that we need to know which tenancies this will apply to and which it won't, at least what the vision is. At the moment, we don't have either of those. We don't have that information. And we don't have, more fundamentally, the law. I'm not necessarily saying that we need the full law. I would like that law to be in place first. But certainly we need to know the framework and the policy, not simply a plan from the last government. I'm seeing some nods from the Chief Minister. I don't think that this should be something that they should dig their heels in over, so I think they could acquiesce to that request and come back and bring us the policy detail so we all know what we're voting on. Well, I mean, so those 2 points, sir.
Thank you very much indeed. Well, if of course the proposer were to be content, then it would be simply a matter of withdrawing the proposition with the leave of the Assembly and coming back on a later day armed with more information. The application for a reference back is in order. It's something on which there is no discretion. It's entitled to be proposed, and the deputy has it seconded, and he has specified the information he's seeking. So the debate is now on the reference back. Does anyone want to speak on the reference back? Deputy Joseph.
Thank you, sir. I will look at the clock and try and limit my remarks. I think my voice is going. Apologies for that. I oppose the reference back. I've heard the observations of Deputy Mezek and others, and I thought the Housing Minister was doing, as this Council Minister is just trying to act by, which is action, not words. We have an imperfect rent tribunal. So it's quite difficult when there's constant chit-chat on the left.
Yes, I'm sorry, I was concentrating on making notes, but I mean, members will please avoid making comments during other speeches, and that way we will...
So if it's me, I apologize. I was asked a question by an assistant minister behind me about the standing orders.
It happens a lot, sir, that's all.
Yes.
It happens a lot.
Well, in principle, no matter who it was, could it not happen again, please?
Thank you, sir. This government is committed to action, not words. We have an imperfect rent tribunal, and the Minister has made it quite clear that the Minister is going to look to the rent tribunal to do the best that they can within the legal powers that they have. But what we're also asking this group of individuals to do is to bring forward forthwith, as soon as possible, changes to their work. And I couldn't think of a better way, and I'm not using words, that was actually a slip, but it is a better way to actually appoint this rent tribunal for them to attend to the work that they can do, and that they can then both use the powers that they've got. And I think that setting up this rent tribunal sends a very clear message that this Assembly and this government is determined to deal with the requirements of appropriate rent tribunal cases as soon as possible. And I'm enthused by that, because I think that's I often say, sir, and I've said in the past, that the best form of regulation is the threat of it. And actually, the fact that there is going to be a rent tribunal in place, imperfect as it is going to make sure, and with the additional remit that the Housing Minister may comment on, which I very much heard him say in his opening remarks, that he's going to bring forward changes as appropriate that can be advanced either by triennial regulations as a standalone body or to amendments under the remit of the law, would be a clear indication that this Assembly wants to see some sort of an organisation, a mandated organisation that's going to deal with the issue of unfair rents. So I don't hear the argument at all for the reference back. We know that there are issues. The reference back isn't going to really tell us any more than we already know, that there are uncertainties in relation to the scope and the ability of the rent tribunal. They can get into office and they can get on and deal with the cases that they can. They can also highlight and hear in public the matters they can do. And so I don't hear that a reference back is going to do anything. The preferable way, I would suggest, is to reject the reference back, appoint these individuals, and actually send a clear message that we're going to have a tribunal dealing with rent control that's also going to be listening and having the ear of an interested minister, a motivated minister, a minister that is very clear, backed by the Council of Ministers, to deal with unfair rents. And that seems to be the most efficacious, the most efficient, and that's delivering action, not words. Because I think the public are sick and tired of hearing words, sir. I don't think we need any more words. We need action, and action can be best delivered by rejecting this reference back, going ahead, appointing this tribunal, and getting them to the work with their dual role, if I may say so. That is a dual role of getting on with what they can do and identifying what they can't do, and advancing, with the Minister and this Assembly's consent as appropriate, the work that they need to do to expend their remit. So I ask members to please carefully consider action, not words. Let's put in place something, and let's let them give them all the possibility, let's give them all the positivity that we possibly can to get on with the task that we need to do in this difficult market. Thank you, sir.
Deputy Mayor Sake.
Thank you, sir. Deputy Ayes have said he hadn't heard a reason for this reference back. That's a natural consequence when you weren't listening properly in the first place. So this reference back is absolutely clear what it's asking for. It's asking for detail on what kinds of tenancies will benefit from the services of this tribunal. And right now, we haven't got a clue. We don't know what types will. The law is written in virtually ancient language that doesn't correspond with the types of words that we use to help identify what kinds of tenancies exist in the year 2022. How many tenancies out there will be able to be subject to the jurisdiction of this tribunal? Is it thousands? Is it hundreds? Is it a handful? When I look at the exemptions that are provided in the 1946 law, my suspicion, and unfortunately it can only be a suspicion because we don't have the information, my suspicion is that this may not actually apply to more than a handful of tenancies. I'd like to know for definite whether that's the case, because I will get constituents coming to me with problems with their rental contracts who will want some form of resolution to those, and if I am directing them to a rent control tribunal which allegedly exists to support them, and then it turns out when they get there it doesn't, I am risking them being subjected to revenge tactics from those who are angry about them standing up for themselves and challenging those practices. And that would be an irresponsible thing for me to do. we're asking the Minister, who in the report to this proposition has provided 3 paragraphs and a sentence before the bios of those who he's asking to appoint, which does not give any indication of what help will actually be available. There's no document of information for prospective users of this service. There's no draft page for the government website for us to be able to flick through and see who will actually be able to benefit from it. But as it currently stands, having heard the answers from the Attorney General, it sounds like those tenancies will be few and far between them, and we don't have absolute clarity on that. If there had been an answer from the Attorney General or from somebody else to be able to say, I can say with confidence looking at this law that this tribunal, if it's re-established, will have the jurisdiction to be able to adjudicate over all ordinary tenancies which currently exist in Jersey under the 2011 law, which is what almost all tenancies, residential tenancies in Jersey will do, then we could breathe a sigh of relief and say, okay, that means we can have a degree of confidence that the Rent Control Tribunal will have some of those powers that it's alleged to have in this proposition. But at the moment, we don't know that. Our strong suspicion is that it might be close to none. And if it is close to none, that has a material difference on whether a proposition should be adopted to establish a tribunal if it's not actually going to be able to carry out the function that it exists in law to be able to carry out. So the reference back is asking for that information. I don't think that's too much to ask. If the Minister can't provide that, then it undermines the value of the proposition. If he can come back and say, and incidentally, sir, he would be coming back at the point that he should have been making this proposition anyway if it weren't for the truncated lodging period. So he could come back and say, these are the types of tenancies that can benefit from this service. And if he can do that, he'd provide great comfort to those who are worried about this. But without that, this proposition is close to meaningless, and we're setting up a body that won't have any power. Like, that will be a waste of time. So let's get that information to determine whether it is a waste of time or not, because it looks like it is, and that's the risk.
David Southern.
Thank you, sir. And my concerns are somewhat different to previous speakers, in that what I'm concerned about is that this body, as currently constituted or suggested, is clearly conflicted and would not make a good body to make rules on tenancies because they are tied by their loyalty to their fellow landlords. And the members will be aware that I brought a proposition.
I hesitate to interrupt you because we are debating that those are arguments against not adopting the main proposition, but as to whether it should be referred back, those don't appear to be any of the reasons that underpin the reference back. In fact, the conflict, the reference back relates to what tenancies does it apply to. So if you could confine yourself to the merits of that as a reference back, that would be in accordance with Standing Order subsection 3.
In that case, hearing your words, if the case for a reference back is the case that needs to be made, then I think I'm going down the wrong track. You're right, sir.
Thank you very much indeed. Deputy Hull.
Thank you, sir. Over the summer, we had 2 lots of young friends whose rents were raised by their landlords by 50%. I contacted the now Minister of Housing and I said, please, can you help? And he said, don't worry, Andy, we're going to set up a tribunal. And I was very, very reassured by that, because I thought was very unfair on my friends. And they've had a really terrible time, and it's been very stressful. And the Housing Minister is trying to do everything he can to help in these situations. It's only today that I realised, thanks to the advice given by the Attorney General, that I realised that, unfortunately, it would not have made any difference to these young friends, and I want it to make difference to them. And so that is why I think it would be sensible if we could refer back so we actually know you know, because we all want the same thing. We all want to help people who are being badly treated. But it does say you can have a reference back if there's any ambiguity or inconsistency in information relating to the proposition, which has already been provided to the states, be clarified. So it isn't, I always support, I really support you, but I just feel that we're not going to be able to help these friends because they've only got a license or something, they've only signed a contract for a year, and we've heard it has to be over 9 years, so they're not going to be helped. And I think we have to say thank you to the people who've offered to stand, to be on this panel, because they're jolly kind and they're giving up their time. But we have to know what we're doing and how we best can help everyone. Thank you.
Deputy Renouf.
So could I just ask before I speak about clarification again on the points, the exact points that we are being asked to refer back on?
Well, as I made a note, it is primarily what tenancies would the tribunal be able to over which tenancies could it exercise any jurisdiction, because that's needed to be known before one knows whether you should set it up and who you should appoint to it. Okay. And I think you've also asked for at least a framework of what the new law, if it is proposed, or the new tribunal will provide for.
Okay, thank you, sir. I hope I can stay within the parameters of that in terms of my comments. So I would say, in a wry kind of way, that rarely have I seen so much energy expended in a determined drive to do nothing. The attempt to refer back is an attempt to delay. It's an attempt to stop action happening. And it ignores the central point which is being made here, which is that we are engaged in a sequence of events. This is not the end of what we're doing. It's the beginning of what we're doing. And it's the beginning of what the Minister is doing. He is keen, at the earliest opportunity he can, to put in place the first building block in a sequence of events, or sequence of measures rather, that we hope will help tackle the crisis. And I think that ability to sort of see this as a process rather than an end point is the critical one here. We are doing the best we can. We're responding to previous debates in which it was explained that the feeling was that the tribunal was not constituted in a sufficiently broad way. And so the Minister has responded to that and come back at the earliest opportunity, too early for some, but the earliest opportunity he can to try and remedy that. But still, that's not good enough. We need more detail. We need everything written down first. That information will come. It's a sequence. It's a sequence. And, you know, I think what this really seems to me to talk to is a real antipathy towards the whole notion of the tribunal. It is not a reference back designed to help us build the tribunal to be something better. It is a reference back as part of a what's beginning to feel like a bit of a guerrilla war to prevent it coming into being. So I feel for that reason that we should reject the reference back, put in place the very first building block, in the full knowledge that more information will come back, and obviously the tribunal won't go into effect without proper terms of references and so on. That's all information that one would expect to come. But let's get on with the first step so that we can move forward. Thank you.
Monitor Harbison-Brillard.
Thank you, sir, and I'm pleased to follow the last speaker, but I don't feel we can proceed on the basis of the uncertainty which has been elucidated earlier on in the debate. And my inclination is that those members who have been put forward are actually being treated unfairly in that they will have just such limited powers to do the work they're expecting to do. It would be better to refer this back. And I would say to the Housing Minister, please accept this reference back. either represent it to the chamber, or even better, withdraw it and resubmit it in a better form so that it is far more palatable for members to be able to support, sir. So I shall be supporting the reference back.
Deputy Scott.
Thank you, sir. It's actually good to hear Deputy Mezek focus on productivity, because that's one of my passions. And we've also had some interesting discussions earlier today, or was it yesterday? Time seems to be becoming a blur, on what are wrecking motions. And it's totally true, there isn't clarity. But maybe, well, I can say there is clarity in this law. Is it actually says in Article 3, for the purposes of this law, the state shall appoint a tribunal to be called the Rent Control Tribunal. We have a legal obligation. So now we're actually having some sort of discussion about what is this, what's the ambit, how many kind of leases are going to come within the remit of this rent tribunal, and we don't know. We don't have the data. There is that need to actually, and as you have already witnessed, my fellow state members, I had an exchange with the Attorney General about how you identify the leases that are excluded, and is it possible that they actually almost like have to self-identify themselves and they might not exist anymore, in which case the scope is a lot broader than perhaps might have first been suggested. So something needs to be established here, and the real question is who should be doing it? Now, I would actually say it's the Rent Tribunal. Its first task is to establish its jurisdiction and to take legal advice, to give guidance on it. At least that's what I would hope it would do. Now, if you refer this to scrutiny, are they going to get the legal advice? Maybe, but, as long as it's got, then maybe that's the real kind of where the need lies. We've also mentioned this concern about conflict of interest. This is a discussion that we've already had in the States Assembly regarding the composition of the tribunal. Sorry,
I think
sir.
some background noise is disturbing the speaker. Obviously, it's always possible for members to speak between each other during the course of a speech. That a lot of important discussions take place in those circumstances, but they must be very much at a whisper, and there shouldn't be a background hum which will disturb a speaker speaking.
Thank you, sir. I would expect this rent tribunal, with its band of professionals, to actually come up with its own, to actually look into questions of how you manage conflict of interest. Most importantly, this panel needs to be adequately resourced. And I really want to emphasise that, because I have actually been part of a statutory panel which actually struggled because it lacked resourcing. And I wasn't talking about people, I was talking about the money, the actual supports. So I'd like us to be holding our minister to account to ensure that this tribunal can be set up, establish what its ambit is, and to actually deliver guidance. Once it's got that legal advice, to be able to say, okay, this is what we can look at. And yes, I agree, it's unfortunate. We don't have a better legal framework in place. It does only deal with dwelling houses. It should be broader. But I do agree, it's a start. I still am aware that there is a law, and maybe somebody who was housing minister before should have gone to repeal it or replace it. I really don't know. I don't think we need to discuss that. I just think we look at the law, and it would be useful for states members to look at laws, given that we pass them, review them, and just think, right, we've got that legal obligation, let's do it, let's show leadership to our community, obey the law, get on with it.
Well, Conrad St Mary.
Thank you, sir. And I have to say I have a large measure of sympathy with Deputy Mezek in this. I think the public as a whole will think at last we are having a rent tribunal put in place, and they will believe that their property, whatever size it might be, may well be within the sphere of its influence. And to be told, not the last minute, because we're all capable of looking at the law ourselves, or to be advised in no uncertain terms that this law might apply only to a limited number of properties, does beg the question as to why it's being introduced in isolation. And I do therefore have a lot of sympathy with the idea of the reference back. I do, though, revert to the earlier question from Deputy Scott of the Attorney General, and if I can read it, the properties to which the law does apply. It says, nothing in this law shall apply to a house or part of a house let for a term of less than 9 years on a written contract which is expressed as conforming and conforms to a standard form of written contract prescribed by regulations made under Article 7. I simply inquire whether the housing manager through the Law Officers Department could actually get specific advice as to whether such regulations have been made. If most properties are not going to be included within the ambit of the current law, yes, sir, I'm in favour of a reference back on the basis that not only that we need to know to what properties that law will apply and to what properties the Rent Tribunal, composed, I'm sure, of very worthy people, will exercise their judgment, but also because I do not believe it is the role of the tribunal itself to determine what that role should be. It is for this Assembly to determine that, and I believe that should be a prerequisite to their appointment. So I shall be supporting the reference back unless the Minister can give me comfort and saying that law is on the brink of being published to that effect. Thank you, sir.
Mr. Attorney, are you able to assist as to whether there have been regulations made under Article 7? Shall we move on and come back to you, Mr. Attorney? Deputy Ward.
Thank you, sir. To stick to the reference back, a reference back is provided as a position in this Assembly if we are looking at trying to find more information so we can make, in my interpretation, a better decision. And that's exactly what we're trying to do here. And I thank the other members of the Assembly who have spoken and are considering exactly that point. I think to talk about this as just the beginning is a notion, but we need to consider that as a notion. And this reference back, what it does is it gives us some detail on what that beginning looks like, because at the moment we don't know what it is. Now, so I don't want to get out of the reference point, but we can't give false hope with a rent tribunal. And I would say we all agree that we want a rent tribunal, but that's just not a name. It's an actual body with teeth. There is not the information currently that it assures us that that body will have teeth, and indeed, from the answers from the Attorney General, it is clear it will not have much of a remit, if any at all, on rented dwellings on this island until that law is changed. I go back to the point, so as well, that this was to be debated in the next sitting, was brought forward. I think it would be really significant in terms of cooperation of this Assembly if the reference back...
Excuse me, the Connotable's anxious to make a contribution to Greffier's collection. Please carry on.
Sorry, sir. I think it would be significant in terms of the way we're going to work across this Assembly on these types of things. It's something we do all agree on. If this reference back would be accepted, more detail would come back to the Assembly, because there's obvious concerns across here. And to be quite frank, sir, I think if the reference back was lost by one vote, for example, it would not be good for the decision-making that we're making. And let's look at the quality of the decision-making. I don't think anyone's opposing a rent tribunal here. What we're trying to say is, can we please know what it means? And the 2 points on the reference back by Deputy Tadger are exactly, I mean, I was thinking there's some others, sir, but we can't add them now, in terms of timescales and et cetera, because timescales are important. But I think they're so important that we have in terms of the debate around this. And also, I totally agree with Constable Jackson when he talks about, are we setting up a panel and really not giving them the opportunity to do the job that we want them to do? Because that's not fair to the panel. Forget who's on it for now. If you're going to set up a panel, let's let them do the job properly for us. Otherwise, they're going to sit there and say, well, the states have set us up for nothing. And it will lose its credibility. And I think this step forward for this island is about credibility, and we'll have more credibility if the reference back is taken and we have that type of detailed information which is clearly needed by members across this assembly. Thank you, sir.
Thank you very much. Deputy Gorst.
Thank you, sir. I think standing orders don't give much flexibility about a judgment on a reference back, sir. So you were requested, it was seconded, information was requested.
Yes.
You had no leeway on whether to...
The first note is there is no discretion allowed for the chair in this. So please, sorry, I didn't mean to interrupt you, but you're absolutely right. There is no leeway.
Thank you, sir. I just wanted to make that point because it does seem slightly strange, because the reference back is not actually in connection with what this proposition is all about. This proposition is a proposal for members of this tribunal. And yet the request from the mover of the reference back is asking for other information, not information around the individuals which the Housing Minister is proposing. But as standing orders allow, that has been allowed. And the reason I make that point is because we know from the debate that was taking place before the reference back was made, at least one individual confirmed that they would be voting against this panel because they thought one individual was inappropriate. And I do think we just need to be careful about whether we're not confusing a number of issues here. I think these individuals are more than eminently suitable to populate this tribunal. That is what the Minister is asking for in this proposition. Are there other questions that the Minister is in the course of answering and working on together with his colleague Minister, the Minister for the Environment? Not the Minister for Energy and Climate Change, but the Minister for the Environment. Yes, there are, and that's perfectly legitimate to ask some of those questions. For my part, that should not stop members from agreeing these eminently suitable individuals to populate this tribunal. And I do start to have nagging or niggling concerns about why we are asking for a reference back and why are we asking for what in effect is further delay. Because as Deputy Howell said, right now, individuals are suffering. And the population of this panel may not indeed help those two individuals, but it is a step on delivering help into the future, rather than a step back and a wait. It's a step forward. And I say that, sir, because many members have stood in this assembly and said we're in a housing crisis. During the election, islanders were asking lots of questions around housing and were feeling hopeless, whether that was in the buying part of the market or encountering difficulties in the rental section of the market. And I'm not sure, sir, that by deferring again, Minister's already been asked to defer this by members. Now he's being asked to defer it again. The Minister is keen, sir, to take action to get things done. He's been not quite Tigger-like, but almost in trying to pull every lever that's available to him and trying to take action, being creative in the action that he is taking in regard to meeting some of the challenges that islanders are facing in regard to housing. And so we find ourselves at that difficult juncture. We could wait again for further information, let the Minister go back and spend a number of weeks answering everybody's legitimate questions about what will or what might or what's possible and when might A happen or B happen or and on and on. Or we can simply say this afternoon, yes, here we've got 5 individuals eminently suitable, been through a good and proper process to populate this tribunal and allow the Minister to get on and start delivering. Or we can defer again, sir. I don't think on balance, perhaps it comes from experience. I've done enough deferring and dithering, sir. Now is the time, I think, to start taking action, and I support the Minister in the action that he's seeking to take today, and I ask members to do the same, sir. Thank you.
Deputy Ward.
I thank all those who have spoken in support. Deputy Reniff, Deputy Scott, you all make really valid points. The point about appointing a tribunal panel or a panel is to do precisely what so many of the Assembly members here in this discussion are wanting to be done. They want to get on, sort out this 1946 law. Deputy Howells makes an absolute point. You know, there are 2 individuals here who've seen huge rental increases. You know, nobody's doing anything about it. Let's try and sort things out. Let's get things moving. If we don't have a panel in place, we can't establish anything. We can't get anything. We can't even begin to get the ball rolling. What annoys me a little bit here is we're the government are accused of scaremongering. Deputy Mezek, there's famous lines of his, I've got here, false hope, revenge evictions, petty debts. You know, it's unbelievable. I've got here, actually, as everybody else is getting legal advice from the Attorney General, I asked for some legal advice of my own. And it says, you can, by ministerial order, increase the 3-month period already a landlord gives notice to quit to a greater period, both in the case of fixed-term tenancies and periodic tenancies. So actually, the Deputy Mezek is not correct in his assertions that these tenants who are unfairly evicted don't have some comeback. So, you know, there are quite a few, we're not allowed to use the term mistruths here, but inaccuracies, put it that way, being mentioned here. So I want to get on and deliver a panel of very, very capable people who will get on and deliver and sort out the issues which have been brought up in this Assembly today. Let's get on with it, and let's do it today, please.
Thank you, sir. I'm actually just going to respond quite quickly to the Housing Minister, because and the reason why we need a reference back is he's referencing a panel and a tribunal. So which one are we forming? Are we forming a panel to help draft the law, or are we forming a tribunal to help with the rents? Because that's not clear in your proposition. So I do believe we need the reference back so we can answer this question before we can appoint the appropriate panel or tribunal.
Does any other member wish to speak? The Attorney General, you wish to offer advice?
Yes, sir. I was asked 2 questions, whether there had been regulations issued under Article 7 of the 1946 law, and the answer to that is yes, they have, but they don't deal, unfortunately, with the standard form of written contract prescribed by regulations under Article 7. Whether they ever did would involve an exercise with the statesgraph to check their drafting file to see whether they ever did contain a standard form of written contract. In terms of the consequences of that, well, it may be said, as Deputy Scott mentioned, well, that may mean that most contracts, because they cannot conform with a standard form of written contract, will not fall within the exclusion. That's a question of fact. I'm afraid I don't know the answer to. It would involve some checking as to whether there is any standard form of provision in a residential lease which deals with this particular issue. In relation to the Minister's question to me about, I think he was referring to the 2011 residential tenancy law. Yes, there is power for the Minister by order to extend the period, which is currently 3 months, by which a landlord can give notice to quit to a tenant, and that can be done by ministerial order. And that is obviously an option which the Minister may wish to consider. I hope that answers the two questions that have been raised.
Now, Deputy, how do you put your light on? You're not entitled to speak
It's a point
again.
of law, really, sir. Sorry,
Firstly,
sorry,
if
sir.
you'd wait for me to finish before you comment back, you're not able to speak more than once. You're entitled, though, to ask a further question of the Attorney General. And so is that what you're wishing to do? I saw your light first. Well, then please do.
Thank you, sir. It's just a point of law. I just wondered, is it for the tribunal panel to change the law, or the Minister to change the law, or this Assembly to change the law? Thank you, sir.
Very straightforward.
So the tribunal panel cannot itself change the 1946 law. That's a matter for this Assembly. As to whether in terms of what it can do, at the moment it has to operate within the current parameters of the law as it stands. It is a creature of statute. Its powers are set out in this law, and it is confined to the jurisdiction that's conferred on it by this 1946 law.
So may I ask a further point of law?
I beg your pardon?
May I ask a further point of legal clarification?
Yes, you can, but I think, Deputy Jean, you wanted to ask a point of law, or did you want to speak?
No, I'd just like to be excused because I've got a doctor's appointment, so I wanted to put it on I just wanted to put it on record, as lots of people seem to do that.
Right, very well. Well, let's
not a point of law, I
take
think.
that as read. Then I'm assuming, Deputy Felton, did you have a question, or did you want to speak?
I wish to speak.
Very well, yes. Deputy, there's a
Thank
further
you, sir.
question for the Attorney.
I thank the Attorney General for his clarification. Would the Attorney General be able to provide some reassurance that the tribunal would be well within their abilities, if requested by the Minister, to suggest law drafting instructions, which would then be brought forward to the Minister and the Assembly for because that's, I think, what the important point is that the law is imperfect, but we're asking effectively, the Minister's indicated that he wants the tribunal to be asked to bring forward changes based upon their experience of the work, and that, of course, they can't pass laws, but they can ask for legal amendments, and that would be perfectly in order for the tribunal to be made, if requested to do so.
In principle, yes, is the answer to the Deputy's question. The law provides at Article 3, at paragraph 4, the Minister may appoint a clerk and such other officers and servants as the Minister thinks fit of the tribunal, and there shall be paid to them such salaries and allowances as the Minister thinks fit. So that confers a jurisdiction on the Minister to provide the tribunal with legal advice or other support that it needs. The panel, I don't see any provision here which would prevent the panel from providing a report to the Minister on what it can and cannot do.
I'm grateful to the Attorney.
Deputy Felton.
Thank you, sir. What I'm hearing here is an awful lot of confusion around what this tribunal will be able to do and also its purpose. And I'm wondering, in fairness to the people being appointed, whether they're actually clear about what's going to be expected of them as well. More importantly, I think it's really important that us as the States Assembly are very clear about what we are appointing people to do and why. Further, I think this reference back is very important because the people that you may appoint to a panel that are going to advise on law changes may well have different skills to the types of people that you might appoint to sit on a tribunal. So we need to be really clear about what the expectations of the people that are being appointed today are, or not today. So I would support the reference back. I think the reference back has actually been brought in the spirit of collaboration so that the whole Assembly can actually get behind the appointment of this tribunal. So I encourage ministers to support this reference back because it will actually enable that collaboration, that openness, and that transparency that you promised us all.
Does any other member wish to speak on the matter of the reference back? Deputy Hebron.
Thank you, sir. As time this afternoon has progressed, I think there has become more and more confusion. Having been somebody that's worked within legislation for over 29 years, it is always important that we are fully clear as to what is expected of us, and that is whatever role we take, whether that be a police officer, customs officer, or a tribunal. We have to be clear about expectations of what we are being asked to deliver. I'm not even going to talk about the fact of whether we do or don't think that the people being asked to be on that panel are suitable or not, because that isn't part of what we're considering this afternoon in relation to the reference back. But I am concerned about the information that has been fed back to us by the Attorney General. And so from my perspective, I want it to be clear to me, as a member of this Assembly and having been elected by St Helier North, that what I am agreeing to. And so therefore, I think a reference back is really needed because we need to be clear about what we are asking this tribunal panel, whatever you like to call them, is being asked to do, because that is, to me, imperative. It needs to be clear to them, it needs to be clear to us. And I also do have clear concerns about when we suggest that they may be bringing forward some forms of legislation, because actually that is our job. And I know people are shaking their heads, but that's exactly what was said behind me, I'm afraid. So I just want some clarity. So I will vote for bringing this, having a reference back, because I think we need clear lines and we need to know what we're doing. Thank you, sir.
Deputy Ballard.
So I think it's not uncommon for debates on references back to generate confusion. And I wonder if I might, first of all, clarify my own mind by asking you whether I have correctly understood the reasons for the reference back, which are firstly to obtain information as to the kind of tenancies which are covered by the law, and secondly, to get some information as to the powers or functions of the tribunal.
I understood the second part of the reference back was to gain information concerning the statutory framework that is proposed in short order under which this panel would function. I didn't understand the second, and I think right. Deputy Taddy is not nodding. So those are the.
Well, thank you, sir. Thank you for assisting with that. I don't think, sir, that either of those grounds justifies a reference back. Article 2 of the 1946 law says that this law shall apply to any contract whereby one person, in this law referred to as the lessor, grants to another person, in this law referred to as the lessee, the right to occupy as a residence a house or part of a house in consideration of a rent. That's the starting point. It is true, as the Attorney General has informed the Assembly, that there are exceptions. And it would be a matter for the tribunal, if it is seized with a reference from a tenant, to decide whether it had jurisdiction under the law to deal with the case or not. Nothing in a reference back is going to change that situation. It's all set out in the law. The law may not be a very good law. The law may be out of date. It may need revision, but it's there. It's in black and white. And it's not an appropriate ground, in my view, for a reference back to ask for clarification of what is in a law. Now, as to the second point, it seems to me that it's only when the tribunal is established and operating that it will be possible to establish clearly what the defects of the 1946 law are. If, for example, the tribunal finds that it does not have jurisdiction to deal with a particular case, then clearly that's a case for, if the Assembly agrees, for changing the law to make sure that the jurisdiction is extended. But to suggest that the Minister should come back and say what he's going to do before he's had the experience of what the tribunal is doing seems to me to be putting the cart before the horse. In my view, sir, the reference back should be rejected.
Does any other member wish to speak on the reference back? No other member wish to... Chief Minister?
Well, simply to say, really, I think Deputy Balash has taken the words out of my mouth and expressed it in a much more eloquent way than I could. So I thank him for his words. Really, this is an unfortunate situation to be in, and I really do not think that the Assembly intends to slow down the progress that the Housing Minister wishes to make. But unfortunately, that would be the situation if the Assembly voted for this reference back. So I do ask members to support us in continuing to drive forward, developing the changes that are necessary to the residential tenancy law in order to make this tribunal function properly and in the way that we all hope that it will. And so I do ask you to reject the reference back and let us make progress. Thank you.
Very much, Chief Minister. Does any other member wish to speak on the issue of the reference back? No other member wish to speak. I close the debate and call upon Deputy Taddy to respond.
First of all, sir, can I thank you for clarifying as the debate went along exactly what the 2 points were. I think that should be fresh in members' minds now. And they're two valid points that first of all meet the requirement for reference back. And I think these are pieces of information which not just this Assembly and not just this particular variation of democracy that we have in distribution of seats, but any self-respecting Assembly should be asking for exactly the kind of information that we are seeking here so that we know exactly the future direction. I'll deal with that point first before coming on to the second point to address Deputy Balash's points. Is that it's fair enough to say, oh, let's take a first step. But whenever I go somewhere into new territory and I don't know my way around, I put my phone on and I put on the maps function and I find out where it is that I need to get to and what the direction is to get me there. Because if I just say, well, it doesn't matter, I'll do that later, I'll start walking, I'll take the first step and then the second step. And then you find out, actually, I've gone in completely the wrong direction and I've got into all sorts of trouble because I need to be over there, not over there. And so you have to do a complete U-turn, perhaps not for the first time today, and go in a different direction. So it's really important that we know exactly what we're doing, not for the sake of us, not because of any pride that we might feel in as ministers or as backbenchers, but to make sure that if we are giving a new tribunal that hasn't existed for quite a while to come into existence, we need to know what their raison d'etre is. It's a bit like Aladdin summoning the genie at the Christmas pantomime. And then the genie comes out of the bottle or the lamp and says, okay, what do you want me to do? Oh, I hadn't really thought about that. well, it's a shame because you've got 3 wishes and you need to use them. Well, can you help me decide what I want to do? No, I can't do that. That's not my job. The law of being a genie doesn't allow me to do that. Do you maybe fancy putting me back in the lamp and then calling me when you need me to do some proper work? Because this is the way we're treating these, no doubt, very esteemed individuals, putting them in an invidious position. And I would say to Deputy Balash that the confusion started a long time before the reference back was appointed. The reference back came because there was confusion and we didn't know the grounds that we're dealing with, not the other way around. And if there is a cart being put before any horse, it's exactly the minister, unfortunately, who's doing this again. The minister can't say, I want to set up a panel. Okay, really it's a tribunal. It's a tribunal I'm setting up, but actually I want to set up a policy panel. I can't call it that because the last government had a penchant for policy panels, and we didn't really like them because, especially this one, they're not elected members. It's not for us to appoint members of the public who have no mandate to come up with policy for ministers because they don't know what they're doing. That's the way it looks, and that's the effect that it will have. And I think the Attorney General has been quite clear. It's not simply convinced me or my party colleagues, but I noticed there was an intervention from my constable in St Brelard who said, actually, we don't have the right information. I even read between the lines earlier. That's what Deputy Scott was saying. She's willing to go along with it, but the information is not there. And if I were talking to the ministers perhaps more informally outside, if I'd had the ability, I'd say, look, you know, why are you resisting this reference back? It's in your own interest. It's in the panel, in the tribunal's interest to make sure they know that they have the powers. Then we have a question from Deputy Ozef saying, well, you know, ask the Attorney General desperately, after he's given very clear advice that this only applies to a very small subsection of tenancies in Jersey, and I'll get onto that in a moment. He says, but of course, if we wanted to do something different, we're still allowed, aren't we, Attorney General? In the law, we're allowed to do something different at some time in the future if we wanted to do that, and we could appoint clerks, couldn't we? Yes, of course, the Attorney General said, you can do whatever you like, you can appoint clerks. You don't need to ask the Attorney General his permission to do that. You're the government. You do whatever you like, sir. You give the tribunal whatever powers you like that you think that they need to do the job. But the point is we need to know what those powers are. We need to know what the policy framework is that they will be operating under because they need to do it. And our constituents need to know when they pick up the phone and they say, is my tenancy covered by this? Deputy Howell, and it might be someone on my road, it might be one of my neighbours who comes to me and I refer them to Deputy Howell and says, talk to Deputy Howell about this one. You're her constituent. And she says, well, I'm afraid you've got to go and see the panel, but it doesn't necessarily apply to you. So rather than giving people false hope, you want to know that you've got the information that you can vote on where it's completely clear. And it's not for the tribunal to be set up to be developing policy for the minister in the absence of an actual policy and actually a law existing, because we don't have the law in place. But on a more practical point, it's a bit like the gardener, isn't it? You wouldn't ask a gardener to come round and do your garden and say, well, which bit of the garden do you want me to do? So I don't know, it's my wife asked you to do the garden, but she's not here at the moment. And, well, if I've got any tools to do it? No, you haven't got any tools. And well, should I do that bit? I don't know. The gardener says, you know, just forget about it. Call me when you know what you want to do. But if we are to appoint, because ostensibly we're supposed to be appointing members to this panel. Now, we don't know if they've got the requisite skills, not I'm talking intellectually or professionally to do it, but if they don't know what type of people they're going to be dealing with, what cases they're going to be dealing with at a tribunal, we don't know if they're going to be resourced. This proposition doesn't talk about any funding requirements. It says this is cost neutral, no financial and manpower implications. I would like to know, if it is going to be dealing solely with lodging houses, who lives in lodging houses? Tell me. Who tends to live in lodging houses in Jersey? It's people with non-quals. It tends to be foreign nationals. It tends to be people who may not have English as a first language. It might be Polish. It might be Romanians. It might be Portuguese. It might be Kenyans. And do the panel, are we setting them up, the tribunal, let's interchange, do they have the requisite resources that they need to deal with complaints and adjudications in Polish, in Romanian, in Portuguese, possibly even in Swahili? Should we leave that there? I'm not convinced that they do, and I don't think that I or Deputy Howell or the Constable of St Brelard, and hopefully other members have the information that they need to deal with this, sir. So I think I've made the point. I don't wake up in the morning thinking I want to bring a reference back to the Assembly. I do it because as an individual member who's been elected to this Assembly 14 years ago, I have esteem for this place. And when I used to sit in the gallery and look down and see some of the decisions that were made, you can take a win or a loss in politics, sir. It's fine. We all know that that's the way politics works. Sometimes you win, sometimes you lose. But when you see decisions that are being made when you don't have the information and they're effectively unsafe, we don't do ourselves any favours as an Assembly or as an island, sir. And that's simply what I would be looking out for. And I would hope, if ever the boot was on the other foot, that the Assembly would have the decency to tell me if I was making those mistakes, sir.
The appell is called for. I ask members to return to their seat. The vote is on the reference back. I ask the greffier to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. Proposition for a reference back has been adopted. 23 votes pour, 18 votes contre, no abstentions.
Have those for and against, please, sir?
Yes.
Those members voting pour, the Connétable, St Brelard, Trinity, St Peter, St Martin, St John, Grouville, St Mary and St Saviour, and Deputies Southern, Tadier, The Hegara, Rob Ward, Alves, Farnham, Mesick, Coles, Porre, Eltham, Hal, Kovac, Andrews, and the Connétable, St Juan and St Lawrence in the chat. And those members voting contre, the Connétable, St Helier, and Deputies Labby, Luce, Ayer, Gorst, Moore, Osoph, Balish, War, Miles, Scott, Renouf, Rose Binet, Miller, Tom Binet, Alex Curtis, Wilson and Stevenson.
Very well. The next item of public business is the States Employment Board Annual Reporting, P107, lodged by Deputy Andrews. For the purpose of this debate, the main respondent will be the Chief Minister, and I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to request the States Employment Board from January 2023 to publish annually a breakdown of civil servant and public sector worker remuneration across salary bands to be presented as percentages of government department payroll expenditure and overall government department expenditure across all government departments. B, civil servant remuneration over £100,000 to be presented as a percentage of government department payroll expenditure and overall government department expenditure across all government departments. And C, combined consultants' aggregate remuneration to be presented as a percentage of government department expenditure across all government departments.
Before we start, Chief Minister, do I understand correctly that your government is accepting this proposition?
Correct, sir, yes.
Very well. Deputy Andrews.
Thank you, sir. I am delighted to be bringing forward this proposition before the Assembly. During my election, I was absolutely paramount that we had to see structural reorganisation of our government in terms of payroll expenditure. I think what we have really seen in recent years is the expansion of payroll expenditure in terms of headcount, and actually there needs to be a reappraisal. And in order to actually reappraise payroll expenditure, we need to be informed by data. And quite simply, all I am doing is actually looking to ask questions in terms of the data that needs to be collected. Hence why I have been looking at, in particular, salary bands, and salary bands, to be more specifically, mentioned with every single government department, okay? And that is relevant to overall payroll expenditure and overall government department expenditure. But not only that, when we're reading Part B of the proposition, we are looking at those who are remunerated over £100,000. And the same thing will apply. So we're looking at the percentage of those who are receiving £100,000 or more to be derived as a percentage of salary for the department, but also as well as an overall percentage of government department expenditure.
And also when we're looking at the final item as well, we're looking at consultant remuneration. Of course, there will always be a need to use external specialisation. However, we also need to be ensuring that we are holding each government department to account for the use of consultants external to the government. And hence, this is why I have brought forward this proposition. I don't think I really need to be bringing forward any further mention to this debate, and I do look forward to hearing what fellow members have to say. So thank you, sir.
Is the proposition seconded? Colin Thompson, John.
Thank you, sir. Sir, both the State Employment Board and the Council of Ministers have considered the proposal and are pleased to support the proposition. It's crucial that the public sector delivers value for money. And as we heard earlier today, the State Employment Board are working hard in this area. The proposal will produce additional reporting that in turn aids accountability and, importantly, action. So the proposition is supported as a positive step in this direction. Thank you.
Does any other member wish to speak? No other member wishes to speak, then I call upon Deputy Andrews to respond.
I'll call for the appel, sir.
Very well. The appel is called for. I invite members to return to their seat. The vote is on P107. Members have had the opportunity of returning to their seats. I haven't opened the voting. I haven't opened the voting yet. Members have the opportunity of to their seats. I ask the greffier to open the voting. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The proposition has been adopted, 38 votes for, no votes contra, no abstentions. Very well, that's the end of public business, except for the arrangement of future business, and I call upon the Chair of PPC to propose the arrangement for future meetings.
Thank you, sir. The arrangement of public business, as agreed at the previous sitting, the next States meeting begins on Monday the 12th of December at 1:30 p.m. Please expect that this sitting will probably last until Friday afternoon or evening on the 16th of December. Bearing in mind the government plan is usually a long debate, we now have several other items on the agenda, including the hospital review, P109, and P11, the draft health insurance fund, which will elongate what is already a very busy week. I would like to give notice that to be efficient and to get through the extremely busy agenda, we should consider having shorter lunch breaks and finish slightly later each day in order to accommodate public business. And I would like to suggest that we have, instead of a 1.5 hour lunch break, we have an hour lunch break and maybe finish at 6 o'clock each day, which would give us an extra 5 hours.
Right. Well, in which case,
Thank you.
I'll take that as a proposition.
Yes, please, sir.
And we won't, I think, need to second this. Do members agree that we would have a truncated lunch break to last for an hour simply each day as opposed to an hour and a half? Very well, we will do that. And we can deal with 8 sittings as and when as come along, depending upon whether or not that's necessary. Do members agree to adopt the future arrangements for public business proposed by the Chair of PPC? Very well. Thank you very much indeed. The Assembly stands adjourned. So I beg your pardon?
So before the Assembly adjourns, I'm just wondering about the running order for the next States sitting and whether it would be appropriate, sir, given that the proposition I have lodged, P109, could be dependent on the outcome of the government plan debate. So, for example, I have asked for, requested the government to produce some figures based on previous agreements of the States Assembly. So, for example, the Budget, Financing and Land Assembly, P80 2021, sir. If, for example, as I understand, the government were to lodge an amendment which sought to withdraw, for example, the borrowing, approved borrowing, sir, that might impact on my proposition, sir. So I wondered at what time it would be appropriate to ask if the Assembly would consider taking my proposition prior to the government plan debate. If now is the time to request that, so I'd like to do it. Thank you.
Well, I think it is open at the arrangement for future business for members to propose that particular issues are taken in a different order. Consequently, if you wish to make a proposition, Deputy Farnham, that P109 is taken at the, well, it would be effectively at the start of business on the next sitting, then it's open to you to do so.
Thank you, sir. Of course, that would only be necessary if the government were to lodge an amendment which changed one of the previous state's decisions in relation to my amendment. So it's difficult without knowing what the government's proposals are, sir. I don't want to jump the queue. But
well, in which case, perhaps the thing to do is to wait and see if there's an amendment.
The Chief Minister has her light on, sir. So
but the Chief Minister, can you assist with this, Chief Minister?
Well, sir, I'm a little surprised by the Deputy's suggestion, given that we circulated earlier in the week to States members a letter to explain to them exactly how we propose to move forward with the hospital situation. And I would have imagined that that would have given the Deputy all the information that he requires, that he is aware that there is an amendment forthcoming, equally, we expect to have a proposition before the Assembly that will offer time for scrutiny prior to a proper debate in the Assembly, as members would imagine under the processes that we have to operate within.
Well, very well. I'm not, obviously I don't know what the amendment says, Chief Minister. I don't know if Deputy Farnham does, but it may be that the right thing to do is to wait until the beginning of the next sitting, Deputy, and then decide when you know all of the information whether you wish to urge the Assembly to take it as a first item of business.
Yes, I was aware of the correspondence, but until previous experience over many years has taught me to wait for amendments to actually materialise. And so I'm quite happy, sir, to wait to the beginning of the debate, and if necessary, ask the Assembly's forbearance at that stage, sir, to discuss mine first at that stage.
Indeed, and may I respectfully suggest that in the event you wish to make that proposition, you notify members by email as soon as you know you're intending to do so, so that thought can be given to that when you make that.
I will. Thank you, sir, and thank you to the Chief Minister.
Very well. The Assembly stands adjourned until 12th.